Hello, everyone. We'll be getting started. Just give me one moment. Ebony, you're muted.
Okay, we are live streaming and we're going to be getting ready in just a few minutes. Tamika, were you able to go onto the Restream and turn on your, um, where it says toggle on and then just click on your platforms?
Let me go back in there. Quick.
Okay. We're going to get started in just a couple minutes.
Okay.
All righty.
Mine are going.
Let us know when you are ready, Tamika. We're ready when you are.
I am actually ready. Let's.
Okay. Introduce yourself and let's go.
Okay. Hello, I'm Tamika Lewis Mackins with Keller Williams Preferred Realty. And one of the reasons why we're hosting the estate planning workshop tonight is because it has come back by popular demand. This is one of the hottest topics that people always want to hear about when we have our other workshops. And so we're bringing on attorney Ebony Lucas to enlighten us on all things estate planning, from wills, trusts, toadies, the pros and cons of it all. So Ebony, can you give us a little bit of background about you and then go ahead into your presentation?
I absolutely will. But first, can you tell us about you? What do you do? What brokerage you're in? Let's hear a little bit about you before I jump in. Since
Oh,
you're the hostess with the mostest. Let's go.
so so I'm Tamika Lewis Mackins. I am with Keller Williams Preferred Realty. I have been in the business for going on 11 years now. I am a licensed chiropractor as well as a licensed real estate agent in the Chicagoland area. And so I really love what I do. And we're just trying to be more than just about sales, more of like a community based realtor, and making sure that we're getting the information out to those in need. So it's a little bit about me.
Absolutely. Yes. So I'm Ebony Lucas. I am a real estate attorney and estate planning attorney. That means I represent people when you're buying and selling property. And then I represent people on when they're doing estate planning. And this is really important because estate planning is what allows us to keep what we are building. So it's one thing to go out, close on your home, we get excited, we buy a new place, but then we don't protect it. And what we're seeing with the baby boomers now is that as they transition ownership of property, they are losing wealth. And the biggest reason why they're losing wealth and they're losing the value of their assets that they worked so hard for is that they have a lack of protection. And a lot of people think that estate planning is just about death, it's about people dying. But it's not about death. It is about so much more than that. It's about protection, it's about control, it's about legacy, it's about all of these other things that we're passionate about. And we want to make sure that when we work really hard for things, that we're able to keep them and pass them on, and that um, we leave a legacy. And I get this question sometimes, like, what if I don't have any children? Well, legacy is not just about children; it's about scholarship funds and endowment funds that you leave to institutions like hospitals and schools. There's so many options and so many different things that you can do when you have worked for it. And if you're here tonight, you've worked for something and it's important to you. And so, since it's important to you, it should be important and remembered by other people as well. So, I am going to share my screen and we're going to talk about legacy planning. Now, One of the things that I want to talk about is, and I'll give a lot of examples, but I talk a lot. So if you have questions along the way and you just want to put your questions in the chat, feel free to do that. And I'm happy to answer any questions that you have. Let's start with the truth. And that is that research shows that Black wealth will reach 0% by 2053. 65% of white millennials are homeowners, while 33% of Black millennials are homeowners. 77% of Black Americans have no estate plan, and the average cost of probate is $15,000. So if you do not properly estate plan, you have to go to court. That court is called probate court. In that court, the judge decides what happens to your belongings that you work so hard for. But it's not just probate that we're trying to avoid. So we'll talk about probate. We're going to talk about Medicaid planning. We're going to talk about a lot of other things, a lot of other reasons why this matters. So the number one reason why it matters is because money stress kills. When we worry about money, because we lack of plan, we have obesity and we have heart attacks and we have all of these other issues. And so we want to avoid that. And as you age, there is very specific research that shows that one of the number one things that when people have something to live for, when they know that they have left a legacy, they actually live longer. So this matters because of longevity. It matters because of loss of wealth. If a property is improperly deeded or there's no estate plan, or you're in a situation where you end up needing Medicaid assistance, but for Medicaid assistance, you have to sell your home and they're going to take the whole value of your home because you didn't properly plan. Those are the things you can avoid with estate planning. Fulfillment as you age. Again, knowing that your family doesn't have to worry about taking care of you because you do have these assets and the assets are properly titled so that if there are any health issues, your child or your family members don't have to spend their entire life savings trying to care for you. That's why estate planning is important. Having your money work for you ensures a comfortable lifestyle, healthcare, and long-term care. Again, thinking about the future, not just about death, but about your long-term care, your lifestyle that you want to live, asset preservation, family legacy, and long-term giving. This is why we estate plan. Now, I'm going to tell you another big one that's not on here, but I do want to make sure that I talk about because I am a mom and Tamika is a mom. And if any of you are parents and you have a child who is 18 years old and they go to college, what happens if that child gets into a car accident or something happens to them medically? When you show up at the hospital and you don't have a power of attorney, they can't talk to you. So part of estate planning is having a medical power of attorney for your children, your college-age children. Those types of things are extremely important. So let's talk about the components of legacy planning. Retirement planning, making sure that you have a hobby or something that you enjoy in place. A savings, making sure that you have savings in place. Continued financial growth, making sure that that savings is in a high yield interest bearing savings account or a brokerage account or a stock account where it's growing. Property ownership, owning some type of real estate that can be a passive income for you and also a place for you to live. Estate planning and long-term care preparation. So legacy planning and long-term planning, a lot of times we just think about, oh, I need to have a will in place. But it's all of these other things that you need to have in place that you have to think about so that and plan for. A lot of it is not just like sitting and thinking and worrying, but it's actually planning and being and actively working on making sure that you have the components of what it takes to actually build a legacy. A legacy is not just about making sure that your children have, but it's making sure that you have as well. as you age. So when we talk about wealth building, we talk about property ownership, growth through brokerage accounts and the HYSA, and estate planning. So estate planning is a form of wealth building. So we hear generational wealth, and that is such a buzzword that people talk about all the time. Okay, well, I'm trying to build generational wealth. I'm trying to build generational wealth. And then you say, okay, great. So you have this job, you work a lot, you bought this beautiful house, you have your 401k in place, you have all these things in place, but have you really built generational wealth if you don't have a plan to actually pass it down to the next generation? You haven't. So you have to have that plan in place. And a lot of times, so there's, and we'll talk about the different types of things that there are, but a lot of times people think, oh, okay, well, I've already given somebody a power of attorney. Well, a power of attorney dies when you do. So what happens after that? So when we're thinking about preserving what you're working so hard for, you want to know, is your property properly deeded? What do I mean by that? Well, if you have a property and it is in your personal name and you need to go to you have to go to a rehab facility, or you need some type of long-term care, you need a caregiver to come to your home, if you qualify, or you would have otherwise qualified for Medicaid, they say, okay, great, we'll give you all these wonderful services that the government pays for, but you have to give us your home. But if that property is in a trust, if it is in an irrevocable living trust, then you don't have to turn it over. You can actually keep it. So now you're actually preserving what you had and still qualifying for benefits. Is your money maximized? Making sure that you have brokerage accounts and high yield interest bearing savings accounts. And again, that those accounts are in a trust. All of this, you're making sure that all of your assets are properly titled and in proper order, so that if you need to pass it down to someone, when you need to pass it down to someone, it is orderly. Now, why do I talk about a trust and not a will? A will is, it's sort of old school, right? So there are reasons why we use wills, but wills are no longer the primary document that we use for estate planning. Why is that? Because a will is a direction to the court. Now, I'm going to say that again. A will is a direction to the court. So if you ever have to remember why you would do a trust instead of a will is a direction to the court. And as I mentioned, probate costs $15,000. That's the average cost of probate if you have to go to probate court, right? So you're going to pay the court $15,000, and there may not be enough money there. And so what happens then? Families walk away from properties because they say, you know what? It's too expensive for me to go to court to try to figure this thing out. So I'm not even going to deal with it. I don't have the money to pay for that, or I don't want to pay for that. So a will is an instruction to the court, meaning that your family 100% has to go to court if you only have a will in place. So we do a trust. We do a revocable living trust for any assets that we think we might use during our lifetime, properties that you may sell during your lifetime, that kind of thing. You can use an irrevocable living trust for things that you will not use during your lifetime. Say, for example, your primary residence. You may live there until you die, and that's okay. But you want to put it in an irrevocable living trust so that the government can take it should you need additional healthcare support. And then there are land trusts. Land trusts only cover land. I don't recommend them because if you have to do a land trust, which are very expensive, you also have to do some other type of trust for all of your other assets. So you might as well do it one time the right way. Then after you establish your trust, you have to fund the trust. What does that mean? That means that you don't just have a stack of papers, which I'll tell you a story. My parents, I was like, oh, what do you guys have in place for your estate planning? And they're like, oh, we did that a long time ago. It's all taken care of. And I was like, well, let me see it. and we looked at the documents and we found out that number one, the trustee, they did it when I was in high school. The trustee was my godfather, and unfortunately my godfather has passed away. So I would have had to go to court. Also, the trust wasn't funded. They had the documents, but they hadn't actually transferred their property into the trust. They hadn't actually have moved their bank accounts into the trust. They hadn't made the trust the beneficiary of their retirement accounts. So there's that second step. So if you go online, there's a lot of online tools right now where you can go online and they say, oh yeah, we'll do free estate planning for you. And you go online and you get the documents. Just know that there is another step. And you should always have those documents reviewed by an attorney, even if they're done online. And you should review them regularly, every 5 to 10 years. And then you want to have family conversations. So another reason why people lose wealth is because their families fight after they pass away. They fight because the documents are not in place, and they fight because the documents are a surprise. We don't want surprises. We want everybody to know what's going on and why. And we can have those family conversations. And sometimes you have family members that you may be estranged from, or you may not have a family. Maybe it's just you, but you have a cousin or a friend or an aunt or an uncle or somebody else that you want to be the trustee and the beneficiary of your assets. Maybe it's a church. Maybe it's a school. It can be anything that you choose, but having the conversation with somebody so that somebody knows where your documents are and what your wishes are before you pass away is very important. Also, if you own a business, those family conversations are extremely important. We want to make sure we don't always pass our businesses down to our children. I have 5 children and none of them want to be lawyers. Does that mean my business just goes away if something were to happen to me? No, like I have chosen other people who are outside of my family, and that's okay. I tell my family, listen, these are the people who are supposed to operate my business should something happen to me. And they hear that, they understand that. And we've had those conversations, so nothing is a surprise and nobody's going to be fighting over anything. They can fight, but it's in writing, so they're limited. So let's talk about the steps to build generational wealth. We just talked about having those family goal expectations. These conversations can be difficult, especially with our aging seniors. People don't necessarily feel comfortable when you're going to them saying, hey, let's talk about what are you going to do with your house when you die? That's a hard conversation to have. But if I can say, I have this family business, or we have this business, or we have this house, and what are the goals and expectations when, as you're aging, do you plan to retire in this home? You do? Okay. Who's going to care for the long-term maintenance of the home so that we don't lose the value of the home as you age? Having those conversations, sort of stepping into the conversation is a lot easier than going over your grandmother's house saying, where's your documents and do you have a will and who are you giving stuff to? It can make people feel less suspicious of you if it really starts out just more so being concerned about them. Talking about, what are the expectations? What are the needs? What may be needed? Are you in a house with stairs and maybe stairs are not practical for you, or maybe they are practical for you, but we just have to be realistic about who's going to take care of upstairs and downstairs. And starting out really being caring and compassionate when you have these conversations is important. Next, if you own a business, if there's family members that are not active in the business and don't understand, they have to understand the role and the responsibility if they're not going to be active in the business. So say, for example, I mentioned that I have a legal business, and my legal business probably won't go to any of my children, but it'll probably go to my nephew who really wants to be a lawyer. And if it goes to him, what is the role, or what do I expect from everybody else? Or do I not expect anything? I just pass it on to my nephew and he gets the money and he gets everything that comes from the business because he's going to operate the business. Those types of conversations, if you own a business, are important. Do you have an existing method or process to settle family disputes? If you do not, this is something you can actually put in your documents. You can actually say, hey, if I want my two kids to make decisions together, but if they can't decide, if they disagree, then I want their Uncle Bill to make the decisions, or I want their Aunt Lucy to step in, or I want to step in, or I'd like a banker, or if they don't agree, then I want to have an appraisal of the property. Creating those systems and methods and processes to settle family disputes is extremely important, because then you again prevent wealth loss from people fighting in court. Your whole goal is, let's avoid going to court and people fighting over my assets to the point where the assets no longer have value. Another way to have these types of conversations is to regularly meet with your family to discuss business issues. Business issues meaning their medical expenses. Do you talk to your elderly people in your family about what their medical expenses are and how they're paying for them, and are they okay financially? And is there deferred maintenance at their home that needs to be taken care of? Having those regular meetings, again, helps to have those conversations, so that when you're having the bigger conversation around, hey, let me take you to a lawyer, we can actually get your stuff down on paper, there's not a mistrust factor there. Next is expectations around formal education. So I've had people come and say, hey, you know what? I want to put this trust together and I want to give it to my grandkids, and my grandkids can have it, but only if they go to college. Well, do you want your grandkid to be surprised after you die that they should have gone to college? No, you want to have the conversations early around, hey, my expectation is that I want you to go to college. And so I'm leaving you this if you go to college. If you don't go to college, then I'm not leaving it to you. Or you don't get it until you're 30 if you don't go to college. So there are requirements and things that you can put in place in your trust. But again, communicating those expectations to your family and making sure that there's open communication around there. Having a meaningful and active retirement plan. Now, you may be wondering, what does that have to do with estate planning? Well, when you have a meaningful and active retirement plan, it also means that you have financially planned. So when you have decided, hey, I love to golf, and I know that as I age, I want to have enough money to golf, I can set aside this money. It is all about financial planning. And part of that is deciding, what does retirement mean to you? When do you want to retire? And what activities do you want to participate when you do that? So that, again, when you create an estate plan, you know what you're reserving for yourself versus what you're planning to pass on as a legacy. Emergency plans. So if something unexpected happens, you're unable to manage your business anymore, you're unable to take care of your bills anymore, it doesn't mean you're dead, but your estate plan will have something in place that says, if you become incapacitated for some reason, a stroke, a heart attack, anything that will require you to have a long-term hospital stay, or have to go to a rehab facility for some time. Maybe you get into a car accident and you're unable to walk, but who is supposed to take care of your bills and make sure that your business is taken care of? When I say business, I mean your mortgage paid, your credit cards paid, your whatever, your taxes paid, so you don't lose your assets because nobody paid the taxes when you were in the hospital and now your property's up for a tax sale. So having that emergency plan in place, and then reviewing your estate plan annually by yourself, making sure it's still valid, but also reviewing it with a professional every 5 to 10 years is extremely important. Now, I've been talking for about 30 minutes, and that's a long time to talk. So I want to stop and give a moment for questions before I move on. Feel free to raise your hand or type the questions in the chat. We're here and we're available to answer any questions that you might have.
I have a
guess I'm
question, Kevin. Oh, go ahead.
Oh, no, go ahead. I'll wait.
Nope, you good. Go ahead.
So you're teaching people how to avoid the probate. But let's say somebody's already in a probate. Would you also be the person to reach out to? Maybe few steps of what it typically takes in probate once they're already in the probate, if you can share some.
Yes, absolutely. So I will tell you that what I have learned is that 9 times out of 10 people who have filed for probate don't need to file for probate. One really good thing in Illinois, for example, they just increased the limit on a small estate. So if someone has bank accounts, retirement accounts that are less than $150,000 and they passed away after August of 2025, if it's less than $150,000, you don't have to go to probate. For a house, if there's only one child or there's multiple children, but they all agree that the property should be sold, and they want to move forward with selling it, and they all are in agreement and everybody can sign off, we can sell the property. So there are a lot of things that we can do to avoid probate. And sometimes people file it unnecessarily. So we need to have those conversations first. Because I find that 9 times out of 10 people have filed it unnecessarily. So that would be the first thing that I would say, is that let's look and see if your probate case is even necessary. If it's necessary, then, let's see where you are with it. Do we need to file a motion with the court to try to get permission to sell the property if you have a property or something like that? Or is it the case that it's unnecessary and we just need to dismiss it? Does that answer your question, Vilma?
Yeah, it did. But if it does, I guess if it is already in the probate, are you the person to reach out as well? Let's say they already know and they tried and they have to be. Then what?
Yes, if you have to be in probate, yes, then we can assist you.
Okay.
Okay.
Thank you.
Yes, no problem.
I have a question. You mentioned irrevocable trust versus revocable trust, right? So when should we do which?
Okay, so an irrevocable trust is really used, like I said, in situations where if you're trying to do Medicaid planning and you think that you might qualify for Medicaid, but you may have to sell some assets in order to get that qualification. Medicaid has a 5-year look back, so the property does have to be in the trust for 5 years. But when you're past that 5-year point, if the property is in an irrevocable living trust, then you still qualify for those government benefits. If the property is in a revocable living trust, you don't qualify, because their thought is you can always sell that property and get the money, and then you can use the money to pay us. But if it's irrevocable, that means that you would have to go to court to change it. So we don't often use the irrevocable unless it's that situation, or people that are like uber wealthy that say, I want to have a portion of my assets that are in this irrevocable trust that we don't want anybody to touch for a generation, but the next generation we want this for. And so they may put it in an irrevocable trust, because then that means they can't use it. It's not used for any other purpose other than what they put in the plan.
Okay, thank you.
Yes.
I
want to say again that a will is an instruction to the court. So we don't really very often use wills other than what we call a pour over will, very sparingly. So great question. This all sounds good, but expensive. How do we start, and what kind of funds are needed to get started? So our office charges $1,500 for estate planning. It's a flat fee as long as there's not multiple properties. if you get to the point where you're having like, 5 and 10 properties, we have to pay the county to record those. So, I mean, there's going to be additional fees just because there's fees, right, that we have to pay. But for one property, a basic estate plan is $1,500. How do you get started? So let me see if I have that on my next slide. Oh, this is just about conversations to have with your family. Okay. So the way that you get started is the first thing that you want to do before you even contact any attorney or anything is to inventory your assets. I'm going to give you guys 3 things to do. Write this down and I'll share it with you. 1, inventory your assets. What does that mean? Well, 60% of Americans do not know how much money is in their bank account. You would not be surprised at how many people say, oh, you know what? I was thinking about this and I completely forgot that I had this bank account over here. I need you, the first step, before you even go to an attorney, write down all of your bank accounts, the financial institution where they are, and the account number. Because if you don't know where your bank accounts are, how do you expect your family to if something was to happen to you? They wouldn't, or they would have to wait for the mail to come, search through your things. It's very stressful. So we like to try to make things as easy on ourselves as possible. So the first thing is inventory your assets. You have a home. Do you know the approximate value of your home? Let's figure that out. You have bank accounts. Where are those bank accounts and what are the account numbers and what financial institutions are they in? Do you have retirement accounts? How much is in your retirement account? What's the account number and what institution is it in? A lot of people don't know. They're like, oh, well, my job does that. Well, your job does that, but it's your money. So know where it is and what the account number is and how much you have in it. So it's really important that you do that. So we're going to inventory our assets. That's number 1. You're going to write down everything that you have that is of value that you believe can be passed on to someone else. And I say larger things, shoes and coats and whatever else, maybe not, but, definitely bank accounts, retirement accounts, brokerage accounts, houses, cars, things that have bigger value. Make sure that you inventory those items. So that's the first step. Second step, you need a trustee. So every estate needs a trustee, meaning a person who is going to administer the trust. That person should be somebody who you trust, somebody who you believe can make solid financial decisions. And so you need to have that person, but you need to have a backup because people pass away unexpectedly. People pass away before you think they should. So you need to have a backup, and then you need to have a backup to the backup. That's where I come in. I can help you with that because there are some financial institutions, some CPAs that will act as your trustee. So we get your trustee down. That's one thing. If you don't know, it's okay, but thinking about those things before you even contact an attorney is helpful. And then the last thing is your beneficiaries. Who do you want to benefit from what you have? If it's your children, that's fine. If it's, you don't have children, but it's another family member, you need to have their names, their social security numbers, and their addresses when you go to meet with the attorney. Why do you need their social security numbers? Because believe it or not, as uncommon as Ebony Lucas sounds of a name, I had somebody call me 2 days ago asking me about an Ebony Lucas who lived in Jacksonville, Florida, and I don't live in Florida. So there are people with the same name, even if you think it's an uncommon name. So how does that person go to the bank and identify themselves as somebody who's supposed to be a beneficiary? We need their social security number. We need their address. So knowing the information about your beneficiaries. I can't tell you how many seniors I talk to. We do estate planning and they're like, oh yeah, I want to give it to my grandkids. Great. What are their names? And they don't even know the grandkids' names. So very important that you have that information. So those 3 things, if you have those, is really where you get started. It's really will help you in your process if you start to think about that. The other thing is, if something happens, let's say,
go to like the adoption center.
Let's say, God forbid, you were in a situation where, multiple family members were lost at the same time. And those family members were all named in the document and nobody else and nothing else. So you want to always have a backup. So let's say, for example, my entire family dies in a car accident. What do I want to do? Where do I want my assets to go then? Well, maybe I want them to go to my church. Maybe I want them to go to my school. Maybe I want to open a scholarship in my name or in my child's name. So there's all those options there. But you have to just start thinking about that type of thing before you meet with an attorney. We can certainly help you to think through those things, but at least having an idea is helpful.
I have a question,
Does
Ebony.
the flat fee? Yes, go ahead.
I know we talked about the estate planning with the trust and the wills, but can you touch on toadies? Because that's a word that's thrown around quite often now. All I need is a
Yes.
toady.
Right. Okay. So, if you haven't heard of a toady before, a toady is a transfer on death instrument. So, a transfer on death instrument has to be recorded before a person passes away. I do not recommend them. Here's why. Well, first of all, a lot of people have no idea how to use a transfer on death instrument. They believe that a transfer on death instrument means when somebody dies, I need to go record the paperwork. I have a client who just did that. Their mother died in August. They went in August. They recorded the transfer on death instrument. He went to go try to sell the property, and the title company said, well, the statute says you have to you have to have the transfer on death instrument recorded at least 6 months before the person dies. Well, the average person doesn't know that, and the recorder of deeds will let you record it. They can't give you legal advice. So now you haven't properly recorded it. So what does that mean for my client who has 11 siblings? Well, it may have meant probate, but in Illinois, luckily we have the affidavit of heirship. His 11 siblings are fairly easy to find. They're in contact with each other, so we were able to contact them all and get them to sign. But trust me, it is a nightmare. It is very difficult. They all have to sign the closing documents. So this is 11 people that you got to get to sign the closing documents. It's a mess. So number one, I don't like the transfer on death instrument because if you do it improperly, it's like you didn't do anything. Number two, when you do a transfer on death instrument in Illinois, we have estate taxes. So now when you sell a property, you're going to pay those estate taxes that come along with it, as opposed to if it's in the trust and the money goes into the trust. Number three, it is really not, it doesn't cover any of your other assets. So, okay, fine. I do a transfer on death instrument for my house. What about anything else that I might have? There's no plan for it. So it's very limited. It's limited to just transferring the property on your death. It doesn't provide any Medicaid protection. So let's say, for example, you would have qualified for Medicaid. They don't say, oh, well, you had to transfer on death instrument. You're not going to have to sell your house. You're going to have to sell your house if you need the additional care. Unfortunately, that's how healthcare works in the United States. So you're in that situation. So there's a lot of misinformation about the transfer on death instrument. I am not a fan of it just because it's not all that it's cracked up to be.
Okay, awesome. Thank you. And,
No problem. So I'm going to answer a couple more questions. Does the flat fee include the process of transferring assets to fund the trust? Yes. So the process actually includes the drafting of the documents. It doesn't include the fees to actually draft them. And I think the county charges like $107 here in Illinois. But they're, whatever the county charges, that's what you pay. And it says, does and how would this apply if you live in the United States and have assets in other countries? Great question. So in other countries, we can put those your trust. The only thing about it is that you have to just be, because some places have transfer taxes, estate taxes, some places don't. So, just knowing what those laws are and what taxes people will have to pay. But you can certainly put those assets in trust. The other question Or another thing that people don't talk about a lot is animals. Have a pet trust. A pet trust just makes sure that somebody's going to take care of your pet should something happen to you. A special needs trust, if you have a special needs child or family member that you care for, making sure that that person is cared for should something happen to you. That type of planning would also go into your trust, and it's very important as well. So someone asked about the TODI and the taxes. So the state of Illinois charges the state taxes, and it would probably be best to talk to an accountant about how much those taxes are. So we talked a little bit about conversations to have with your family, just making sure that you know where important documents are. If an emergency happens, who handles financial decisions? Are your beneficiaries current? If they do have things in place, again, making sure that you have an attorney take a look at your documents every 5 to 10 years. We have a really cool tool in our office where we use a system. I actually had an app built for estate planning, and that app will actually take your old estate plan, it'll review it, it'll tell us like where all the shortcomings are in it. It creates a family tree. It helps to summarize what your net worth is and what the value of your assets are. So it's a really cool tool that you can use. I'm getting an echo.
Okay. Oh, I just got on here.
Oh, maybe wait a minute. Okay, there we go. Echo is gone. All right. So, so it's a really cool tool that we're able to do to actually take a look at any current plans that your family members or you may have, and make sure that they're updated. Talking about what your family values are and what you want to preserve as a family so that you understand what's important or what your family needs. And also making sure that you have support in order. So who is your family attorney? Who is your accountant? If you own real estate, who is your management company? Those types of things, you want to make sure that you have those conversations with your family members as you're going through your estate planning process and as you review your estate plan. So I will take other questions. Okay, how should your properties be titled? So that's a great question. And I got this yesterday. I had a client call me, and he has an FHA property, and he was worried if he transferred his property from himself to the estate or to the trust, would the due on sale clause be triggered and he have to pay his whole mortgage back? And the answer is no. So the federal government actually thought about this, like, hey, some people may want to estate plan. Actually, estate planning is important, and we want people to estate plan. So if you transfer your property from yourself to a trust, it does not trigger the due on sale clause. You do not have any issues with your mortgage. You don't have to call your mortgage company and get authorization. So your trust basically is, so the property is actually titled in the name of the trust. So it may be the Ebony Lucas Revocable Living Trust or the Lucas Family Revocable Living Trust. Some people name it something that's not their name. So, I mean, you can name it whatever you want to name it. It's a family document that stays within your family. It is not recorded anywhere publicly. So that's another thing that's good for a trust when you establish it, is that it's not recorded anywhere. So, nobody gets to see what your assets are, unlike court. If you go to probate court, guess what? They have a whole list of all your assets in there. And it's all public record. So that's another thing that another advantage of estate planning is it preserves some anonymity and privacy when it comes to what your assets are and what your legacy is. Can estate planning help to reduce real estate taxes? No. I'm assuming you mean property taxes, and the answer is no on that. Should your LLC be included in your estate plan? Yes. Not only should it be included, but every business owner should have a business succession plan. That business succession plan should look like what happens when I retire, when do I want to retire, who's to operate my business if something were to happen to me and I'm incapacitated for some short or long period of time. All of those things should be in business succession plan is a part of.
Ebony, you
So
froze.
creating those minimum. Does your trustee have to be an Illinois resident? Can you hear me?
I can hear you now. Yeah.
Okay. So your estate plan does not have to, I mean, your trustee does not have to be an Illinois resident, nor do your beneficiaries. Any other questions?
I actually have one more question.
Yes.
Somebody asked, and it was just a client that was close to me, but he asked me if I would be, and I forgot the name for that person, but basically if he dies, they need Illinois resident to take care of the belongings and all of the, I guess, functions that need to be done at the house, because the rest of the family was outside of the state and they could not be, and I forgot if it was power of attorney or trustee or maybe something else. And that's what I was asking about, if it makes sense.
Yes. So it couldn't be a power of attorney because a power of attorney dies with the person. So if somebody passes away, a power of attorney is no good anymore. A lot of people don't realize that, and they'll put a power of attorney in place and they think, oh, I have a power of attorney, so I'm all set. I don't need to do anything else. You absolutely need to do something else. You have to have an estate, some type of plan in place. And what you're talking about is being the trustee. So if somebody is the trustee, they can help to pass on assets. It is a great way for, I don't know how many realtors we have on here, but a great way for realtors to develop long-term relationships with your client. You don't necessarily have to be trustee for the entire estate, but you can say, hey, if something were to happen to you, I would be the one to prepare your property and list your property to make sure that your family gets the money, when we sell the property. It's a great way to just have an ongoing relationship. So absolutely, it's a good thing to do.
Okay, thank you.
And I guess the biggest question there is like, what is the legal liability when it comes to that? Because sometimes people are like, oh, I don't know if I want to be somebody's trustee because there might be some type of legal liability with it. And really the only liability around it is, making sure that you're doing whatever it is that the person says their wishes are.
I have a question.
So I want to share with you guys this link that I have. I just put it in the chat. It basically is a, oh, shoot, wait a minute. I'm sending it to the waiting room and not.
And when you finish, Shamika has a question too.
Okay, yes. So this link is actually like a personalized legacy planning checkup. And so you can actually go on there, you can do the checkup, put your information in there and just kind of get a little information about kind of where you are now and what you may need to do in terms of estate planning. It also has some additional information in it that you can read if you are a reader and you like to actually see things in front of you about estate planning. Yes, Shamika?
Yeah, hi. So say, for example, I create an irrevocable trust and I have my kids as my they're the beneficiaries, or I guess, is that the word that I'm using, that I should use for the irrevocable trust? And then as they get older, they establish businesses of their own and properties of their own and assets and stuff like that. They would then, because it's more than one, they can add to that same trust that I've already started, or would they have to create one of their own?
So
how does that
likely they would create their own for their separate assets. Especially if they're gonna have, their own children and their own families, they would probably create a separate trust. But people can create sub-trusts. So, for example, my parents, in their trust, they have to, me and my brother, they want to give their house and whatever other assets they want to give us. But let's say we decide, hey, you know what? I really don't need those assets and I don't want those assets, but I would like those assets to go to my great grandchildren. I can then take the trust that they created and create what's called a sub-trust. So I'm not actually creating a new trust. I'm just doing a sub-trust that says I'm going to take those same assets, but I'm going to give them to somebody else.
Okay.
That is different from what you're talking about, which is they have completely separate assets from you and they're creating their own personal trust for the assets that they have.
Okay. Thank you.
Carla. I think Carla
Yeah.
was like, Tanika.
I was looking, where do I write it? Or if I talk, you can just hear me?
I can hear you, yes.
Oh, okay. So my question is, the lady who just asked the question before about children, if her kids are underage, something else would have to happen. Even though she left it to her children, it wouldn't go straight to her kids underage.
Well, it's up to her. So let's say your children are underage and you're like, you know what? I need to make sure my kids have the exact same lifestyle that they have right now. And so I want everything to go to them immediately. You can have that happen. I mean, obviously you'd have to have a trustee or somebody that would take care of them and that would manage those funds and that kind of thing, but you can have that happen. Or I've had people say, hey, my kids are underage and right now they're dumb as a box of rocks. So I want to make sure that they have their prefrontal cortex is fully developed. So I don't want them to touch anything until they're age 30. So you can do that as well.
Right, but I'm saying for like her, if her kids are underage and she should expire and she have in her trust her house, she would need a trustee named in that trust in order for things to get handled to her children are of a certain age.
Yes, every trust must have a competent trustee. A competent trustee means someone over the age of 18.
18.
Yep.
Okay.
So
I just said that because I didn't know if she was clear that, she was thinking that when her kids are underage, it would just automatically go to them.
No.
No. Okay.
Oh, no, they're older. My youngest is 18, but thank you.
I think she was asking about her kids having their own stuff and would they create be a part of the same trust or would they have separate trusts?
Okay.
Yeah. Vina?
Hello, how you guys doing? I had a question. I got on a little late and I wanted to know, I have my camera off. I wanted to know a little bit about your firm. Are you a solopreneur? Do you just you and your firm? Are there more attorneys in the firm? Do you just do estate planning or do you do kind of the gamut of everything?
Okay, great question. So I am Ebony Lucas. I do real estate transactions and estate planning. That's it.
Okay.
I have been practicing law for 24 years now.
Okay.
And I have my own law firm. It's called the Closing Firm LLC.
Okay.
And it's myself. I don't do litigation, so I have another attorney who works directly with my office who does any probate matters. So if there's a matter that's actually in court, she would handle those matters. They still go through my firm, but I just, kind of hand those off to her. I am a transactional attorney, meaning I like to deal with paperwork. So if you're selling a property, buying a property, I'm going to closing with you. I'm drafting these types of documents. So that's what I do.
Okay.
I am also an author. I wrote a book called Rooted and Rich, 9 Mantras and Moves to Financial Freedom, where I talk about how to create a plan for financial freedom and diversify your assets. I'm just a lover of conversations that have to do with money. So that is
Okay.
who I am. I not only like to make my own money, I like to help other people make money. So I love having these types of conversations. I'm a real estate investor as well. So I work very well with investors. I can bring a lot of resources in terms of lenders if you're looking to invest in property. So I like to help other people build wealth. And that is sort of my personal mission. I help people build wealth through real estate and keep it.
Okay. Well, I'm an accountant, CPA. We do similar work then. Okay.
Great. Nice to meet you.
All right. Thank you.
You're welcome. Tamika. You're on mute, Tamika. Let me unmute you.
Okay, can you hear me now?
Yes.
I had a question earlier. Is how do I decrease the tax burden for my heirs? I know that depending on how you set up your estate planning will determine how they have to pay taxes, correct?
Yes, you have an estate plan in place. That is the best way to do that.
Okay, gotcha.
Yes.
And so I know sometimes they say don't put your child on your like, so for instance, if my dad and I have a property in our name together, and they say don't put the child on the deed because they still have to pay a certain type of tax. How does that work? Are you familiar with that?
So you don't want to put your child on a deed for a variety of different reasons. One is because there's no creditor protection. So let's say they go and get a judgment against them. Now they can also have a judgment against your house. So that's the number one reason and the number one problem that we run into when people add people to their deed. And then they're like, well, I added them. They got this judgment and now I want to take them off. Can't do that. Now you have a lien on your property. So you don't put anybody on your deed ever unless that person is paying you to purchase the deed from you. And so I'm pretty firm about that. There's lots of reasons you don't want to do that, but that's the number one that we see as attorneys that is a nightmare. Do not put anybody on your deed. There's a lot of scams out there as well. People say, oh, people get in financial trouble and they're like, oh, you know what, add me to your deed and then I'll pay off the mortgage and those types of things. That can happen. And people can then be able to get other mortgages on your property. Don't do it. Don't ever put anybody on your deed. At all,
Note,
ever.
note taken.
Not your mama, not your daddy, nobody.
I think we have an iPhone 6. I'm not sure who that is, but they have they hand
Yes.
it too.
Can I answer your question, iPhone 6?
I guess this is me. My name is Audrey.
Hi, Audrey.
I'm in the process of buying a home, and I wanted to create a trust so I can leave my son without the taxes, like she was explaining. And then when you lower your, like you said, that he would, if his name is in the trust, you still have to have the trustee, because I missed part of what you was explaining because I got locked out. And I wanted to make
Yeah, so every trust must have a trustee that is competent, meaning they're over the age of 18 and they're mentally able to understand the documents. So if you, regardless of age, so sometimes people have adult children and they, for example, like my parents, they now change their trustees to be me and my brother. We are also the beneficiaries. So the trustees and the beneficiaries can be the same people as long as they're over the age of 18 and mentally competent.
Okay. And
If
then,
he's younger than, if your son is younger than 18, then you need to have a trustee that's somebody else.
okay, but like you said, if he's not mentally competent, then you would still have to have someone to um, help that out, right? Yeah.
That
And
is
then,
correct. If he's not mentally competent, you would need somebody, and you probably should also have what's called a special needs trust. A special needs trust makes sure that your child is taken care of if they are not mentally or physically able to take care of themselves. You have a child with cerebral palsy, you have a child with severe mental health issues. A special needs trust makes sure that there's money and assets there available to take care of them and a plan for them. So, I have a client who has she has a child that has very severe physical and mental disabilities.
mhm,
And she takes care of him at home. And, she has 24-hour nurses and people that take care of the child if she has to go to work. But she also realizes that if something happens to her, the child is not going to have that same, like, there's nobody else that's going to ever dedicate their lives to that child in the way that she's done. So in her special needs trust, what she had to do was find a facility that she's comfortable with for her child to go to. And she wants all of her assets to go to pay for that facility for her child if something were to happen to her. That way,
mhm,
she's making sure that her child is taken care of. So if you have a child that has limitations, whether they're mental limitations, physical limitations, you need a plan for who is going to, where are they supposed to go? Who is supposed to take care of them? And if they can't be taken care of in somebody else's home, is there a hospital? Is there a facility that you want them to go to? You get to choose that before something happens to you and there's not a plan.
thank you.
Yes. Can you have more than one person named as a trustee, and does the same apply to beneficiaries? Yes, you can have multiple people named as your beneficiaries, and you can have multiple people named as your trustee. My recommendation is that you have no more than 2 people named as the trustee, and if you want people to be co-trustees, you need a tiebreaker. Who is the tiebreaker? But typically what I say is, everybody has the responsible child. So if it's a matter of children, make the responsible one, the more responsible one, the first trustee, and the other one, the backup trustee. And then after that, if you think that you're going to have assets that go beyond one generation, you may want to have a trustee appointed that would be an institution. There are also really cool programs at like the American Heart Association and St. Jude Hospital, and some other charities have Ronald McDonald House, where they will put like bricks in your name. They'll do different things if you donate your assets to them. I've had clients who donate to Moody Bible Institute. So these institutions, I had a client who donated her house to Catholic Charities. So your legacy doesn't have to be left with a child, but you do, let's say, for example, you decide to name, Catholic Charities as your beneficiary. Well, who's the person that knows where your paperwork is to make sure that that happens? That's your trustee.
So I have another question. So the trustee doesn't necessarily get the benefit of the trust. They just pretty much make sure that whatever you put in the trust is allocated to whom and how it should be.
Correct. It's called administration. They administer the trust. But
Okay.
like I said, your trustee and your beneficiaries can be the same people. It doesn't have to be a different person.
Okay, gotcha. And then I have one more question. Sorry. So,
Mhm. No
so I
problem.
know that you mentioned earlier that there were clauses that you can add regarding the trust. Is this overstepping, or is it possible to add something to say, for example, my kids have to have a what is it called? Well, if they were to get married, they have to have
A
what is it
prenup?
called? Yeah, a prenup in order to benefit from the trust if they were to get married, just to ensure that everyone that I name in the trust, and it's not taken from, there, it's not whoever they marry, it's not taken from them, if that makes sense.
So you cannot require somebody else to have a prenup because that's like requiring somebody else to enter into a contract. But you can say that this is to go to my child and their children, if you wanted to go to their children, but no spouses. And people do that on a regular basis. I've had clients that are like, look, I can't stand my my son-in-law, and I don't want a dime to go to my son-in-law. I don't know why my daughter is with them. And I'm like, well, we can write it up so it goes to your daughter only. It doesn't go like if something happens to your daughter, do you want it to go to the children? Yeah, okay, yes, but not until they're 30 so that they don't give it to their dad. Okay, well, that's how we write it up. So you can write it up in a way that definitely says that if they were to divorce or something, that the spouse does not benefit. But if you don't put that in there, they do benefit. They do get it.
Okay, got it. Thank you.
So the other thing is, I would say, make sure that if you have life insurance policies, these policies and plans, funny story. So my brother and my sister-in-law, they put together a trust when they first got married and they were in their 20s and they didn't have any children. And they named my son and their two nephews as the beneficiary. So my son is now, well, this was maybe about 3 years ago. So my son was 20 and they have two children. Well, they never revisited their plan. And there's my son and their other nephews and not their own children were their beneficiaries. So if something happened to them, thank God nothing has. But if they had passed away, their kids would have gotten nothing. I've had situations like that where somebody's ex-wife was named and they died and the new wife was like, the ex-wife is the beneficiary, but I've been their wife for 20 years. I've been here for 20 years. They've been divorced. Well, but they never changed the beneficiary. Make sure that you change those beneficiaries, that you look at those beneficiaries. People have bank accounts. They have no beneficiary at all whatsoever. The reason why, when we think about estate planning, it's not, again, just about death. It's not just about writing these documents, but it's making sure that all of that stuff is in place so that if you are incapacitated in any way, if somebody needs to take care of your business, they can take care of it without it being even more of a stressful situation.
Is it possible to include the children that are not born yet?
You can, yes.
Do we have any more questions? Audrey, you had another question?
Yes, when you said that you can put your kids in there without being born yet, what do that mean? That you have to they put it in there, how it just be in the trust, and then when
Yeah, it
they
would be in the
they
trust. It would just say if I have children in the future, then that I want things to go to them. But obviously, you would have to have another contingency in case you don't have children. But, you know, a lot of times people put it, let's say, for example, you're pregnant and like something happens and, you know, I mean, you have to think about that. Like people die in childbirth unexpectedly. So having a trust in place that says, you know, I'm giving this to my unborn child if they survive me for any reason. So you can definitely put that in place. Um, but then you just have to have a contingency. Let's say, for example, that child dies. Well, then what else?
Okay. And then I had another question about the I I don't know if you touched on it or not, but about the taxes, because I thought that when you're alive, your taxes, when you put it in a trust and then you have it in that trustee's name, then the taxes stays the same that when you had the taxes when you purchased the house or whatever.
Yeah, I think what
Um,
you're talking about is the tax basis.
yes, I think
And
I'm,
yeah, if you transfer the property before, that's only if you fully transfer it. So sometimes people transfer the property fully before um they transfer the property fully. So like in the situation with Tamika, let's say for example, if her dad, instead of adding her to the deed, transferred her to the property completely, like put her name on the deed and took his name off altogether.
oh, okay.
Then she, instead of being able to benefit from the price that he paid for the property, she would have to actually pay taxes based on what the value of the property is when it was transferred, the estate taxes. So that's what that impacts.
So then that would be more.
Correct.
And then if she was just
Because
on the
basically it's considered a gift. Like if somebody gives you a gift, you have to pay
mm,
taxes on that gift. Just like when people win the lottery and they have to pay taxes, it's the same thing.
so then what was the purpose of you being on the trust? I thought to say it don't save you more money
No,
or
that,
it don't.
yeah, that's if you don't have a trust. So if you have a trust, then everything would be in the name of the trust. It wouldn't go to somebody's personal name.
Okay. 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 Thank you.
Hmm.
So I have two comments from experiences that I've dealt with. So when my mother passed in 2013, she did not have a trust or anything in place, but she did have a will. We learned the hard way that that will was not worth the paper it was wrote on. She had money in her bank, but it cost more to hire an attorney at that time to do the probate than what she had left available. So that money just sat in the state of Florida. We just let it go. We didn't know what to do. So when you talk about, hey, will is the direction to the court, now I really understand what that really means because it didn't help us at all. And then I had another case in which a client, grandmother left them the house. They didn't pay taxes on it. No one taught them what to do once a property was transferred over. So if you're going to be transferring stuff over or you have a trust, you please educate your loved ones on what they need to do once it's transferred, because this young lady almost lost the house due to a tax sale. Fortunately, we were able to sell that house prior to right before her redemption period was up, but she would have lost thousands in equity that her grandma left her as a gift just because they didn't know what to do. And her grandmother had a trust and had everything set up properly, but the next generation almost lost it. So that is the main reason why we try to host these workshops and educational programs in the community, just to make sure that we inform you on just your things that we should be informed on. My question to you, I guess everyone who registered, we're going to send a feedback form, and we want to know what other educational workshops you would like to hear or attend. Some of them will be hosted at the local businesses around the Chicagoland area, and some of them will be hosted at the public library. But we'll be interested in seeing what are the things that you guys feel that you need. Now in February, on February, let me get the date. Ebony, do you have that sheet that Jason sent you?
I can look it up.
If not, I can find it. I'm just trying to pull it up. 1 second. In February, we're going to be hosting another workshop, which will be in person, weather permitting, learning, which will teach you how to build wealth through insurance. There's different insurance vehicles that we can utilize to help you build wealth for you and your family. And we have an insurance agents coming in to teach us about that in different aspects and that. And in some cases, you can even put those into your trust as well. But the next event that we are hosting is Legacy After Dark, which is a networking event bringing investors, attorneys, contractors, lenders, all into one room, and other entrepreneurs. And it's speed networking. So we have about 5 minutes to talk with each professional, and we're raffling off different prizes. That next event will be next Wednesday on the 28th at the View Restaurant. We'll send you the link for that if you want to register. It is free. We hope to see you there. And if you have any other questions, please don't hesitate to reach out to me or Ebony. My phone number is 847-445-0542. We'll be sending you that contact information out. Ebony, did you have any final words?
And I also posted my my contact information. I'll bring it back up on the screen real quick. Give me 1 second. Don't forget, in the chat, I actually have the link to the free estate planning checkup. And here is my contact information if you want to reach out. I will also put so my email is elucas@theclosingfirmllc.com. If you want to schedule a meeting with me, you can go to bit.ly/LucasTheCloser. And that is also my name on all social media platforms. It's Lucas the Closer. If you want to look back over this event that we're having this evening, you can follow me on Facebook or Instagram or YouTube or TikTok. And it's Lucas the Closer on all platforms. I'm also providing a link to my book, which is Rooted and Rich, 9 Mantras and Moves to Financial Freedom. And we appreciate you all for joining us this evening. Thank you, thank you, thank you. We hope that this information was helpful, and we look forward to seeing you again. If you have any questions, please feel free to reach out. Good night.
Night.
It definitely was informative. Thank you so much.
No problem.
Good night.
Good night.
Have a good evening.
Good night.
Good night.
We'll leave the links in the chat up for a couple minutes in case anybody needs to grab them.
Okay.
Ebony, where was the email address or your information? I
So-
saw it. It was up there.
I'll put it back up there again. There you go.
Okay.
It's elucas@theclosingfirmllc.com, or you can go to bit.ly/Lucas the Closer.
Okay, here it is now. It wasn't there. Okay. Look at the close. Okay. And what's this bit? B-I-T? Is that
Yes, bit.ly/Lucas the Closer. If you that have a link on there where you can schedule a meeting.
Oh, so either one of those?
Yeah, one is my email and the other one is a link where you can schedule a meeting.
Oh, okay.
So you can either email me or you can just, like, some people just like to put it on their calendar, and you can do that as well. Stay warm, everybody.
Yeah, it's cold. It's really cold.
It is. It is. Thank you.
Thank
Thank you so much for joining us this evening.
Mm-hmm.
Thank you. It was informative.
Good. I'm glad you liked it.